case on this morning's docket. Case number 108425, Lumry v. State of Kansas et al.
Please the court, I'm Alan Johnson, and I would like to reserve 3 minutes of my time for rebuttal.
3 minutes is granted.
Thank you. As the court knows from reading the briefs in this case, the plaintiff is a former agent of the Kansas Bureau of Investigation, and he contends that he was terminated from his employment in retaliation for complaining about unpaid overtime. In this suit, he filed 2 separate claims, one under federal law, one under state law. His federal claim is asserted against Robert Blecka, the former director of the KBI, in his individual capacity under the Federal Labor Standards Act. And the second claim is a state law claim under Kansas common law under a tort theory of retaliatory discharge based on public policy. The Court of Appeals, in a split decision, affirmed the summary judgment against Mr. Lumry on both of those claims for 2 basic reasons, and those are the 2 reasons I want to focus on in my argument today. The first reason that the Court of Appeals found was that Mr. Lumry had not come forward with sufficient evidence to show that he had engaged in protected activity. In other words, that he had not complained about unpaid compensation. Now, that element, according to the Court of Appeals, is common to both of the claims, and I agree with that. The Court of Appeals also said that the standard for that element was a standard that the U.S. Supreme Court in 2011, while this case was pending, adopted under the Fair Labor Standards Act, and I agree, and I think all the parties have agreed that that is the standard that also applies to the common law claim, although this court has not articulated the element in the common law context in the same language. I think it's substantially or essentially the same. And that standard is, according to the Supreme Court in the Kasten case, is that the complaint must be sufficiently clear for a reasonable employer to understand it in both content and context as an assertion of rights protected by the statute and a call for their protection. Now, there are 2 elements of that standard that I think are important here. One is that it's a reasonable employer standard. That's important because when you're talking about reasonableness and what a reasonable person or a reasonable employer would understand, typically those are the kinds of questions that juries decide after trial, and courts don't decide on summary judgment because the standard is what is reasonable. The other component that's important of that definition is that the complaint has to be viewed in the context in which it is made. So it's a fact-specific analysis. And the context here is important because Mr. Lumry testified that for years, for 8 or 9 years, all of the time during his tenure at the KBI, he had worked unclaimed and unpaid overtime, and that he had been encouraged and persuaded by his supervisors to do that, and that they were aware of doing that, and that typically he had worked 10 to 20 hours of unpaid and unclaimed overtime per week. He further testified that after this period of time, it was taking a toll on himself and on his family. Therefore, he went to his direct supervisor, Clint Hawkins, and told him that he was no longer going to work the 10 to 20 hours of overtime that he had been working and that Mr. Hawkins had expected him to work. He did say, I will work 5 hours a week of unclaimed and unpaid overtime, but I will not work the 10 or 20 hours that I had been working. And Mr. Lumry described this as a tense conversation between himself and Mr. Hawkins. He further testified that Mr. Hawkins replied, well, that's just what you have to do.
Now, take that statement, because this is, on your side, I'm struggling with this issue, so help me. With that, I mean, see, this is easy when somebody's filed a complaint. Then you got it, and you have the protection. But here we've got this statement, and it says you've got this unlawful, well, it doesn't even say that, but you've got, in context, you can say you have this unlawful system, and I'm only going to break the law case law do you think best supports your argument that I can look to see that you're right?
The Caston case itself, just the standard, frankly, the facts of the case, of this particular case, is really not analogous to any other cases, in part because this particular standard was not adopted by the Supreme Court, U.S. Supreme Court, until 2011. And this case was decided at the district court later, shortly after that. But the subsequent cases, in my supplemental brief, probably the best case I cite is a Fifth Circuit case in which the court did apply the Caston case, and they said that the hallmark of a complaint is not voicing a violation of the FLSA. They said you don't have to use that terminology, those magic words, but you have to assert your rights under that statute, and you have to take a position that is contrary to your employer. And that is what I contend a jury could find. Now, I agree that my position is this is a disputed issue of fact that a jury could find, if they viewed the evidence in the light most favorable to Mr. Lumry, that what he was doing was asserting his rights in part under the statute. He was saying, I'll give you 5 hours of unclaimed and unpaid overtime, but I'm not working the 10 and 20 hours that I have been working. So he's asserting his rights under the statute, at least in part. And secondly, he is also taking a position against his employer, because his employer, according to him, wanted him, encouraged him to work the full 10 to 20 hours. And I've quoted...
Could you back up just a second? You said he's asserting his right. Explain to me how he's doing that in his declaration.
Well, in his
His
statement...
statement. I'm looking at his statement.
Right.
How is he asserting his right?
He said, I'm not working more than 5 hours of unpaid and unclaimed overtime. That I had been working the 10 to 20. His supervisor, Mr. Hawkins, was saying, we got to have you working that because we have these drug deals that we need undercover agents working for. And he said, I'm not going to do that anymore.
Asserting his right under the FLSA not to work overtime unless it's compensated.
Correct. And it's really, and it was not only just uncompensated, it was also unclaimed. The KBI had a policy that if you worked overtime, you would be compensated by it. But Mr. Lumry's testimony was that the culture of the KBI, and he testified to that, was that agents would not claim overtime because the KBI didn't have it in their budget. Therefore, they were being encouraged, persuaded by their employers to work this extra overtime. And so, certainly, at least in part, he is making that claim, asserting rights that's contrary to the interests of his employer.
Counsel, if I could, and before you're out of time, ask a question somewhat tangential, I guess, to the discussion you're having, but it's related. Your claim is that your client made an assertion of his rights under the FLSA, correct?
Correct.
And the common law state tort that you're asking this court to recognize now is retaliatory discharge in response to an employee asserting his rights under the FLSA, right?
Not exactly.
Okay, help me understand that.
It's in violation of public policy.
Oh,
And
I understand that's your argument as to why we should recognize the tort. But what I want to drill down to is what your actual claim is. What is the tort? It's retaliatory discharge in response to something. In other words, a public policy you're asking us to recognize that exists in the state of Kansas, that we shouldn't allow employers to undermine employees' rights under the FLSA, correct?
Well, not exactly. My claim was it was under the state law, the public policy that's embedded in the Kansas minimum
Right,
wage
the
and
public
maximum
policy
wage.
would be embedded in the state law. However, Mr. Lumry's employee could not violate the state law because it wasn't applicable to them, at least if you accept the position of stating this, right?
Correct.
And the rights he was advancing, because you recognize that, is under the federal law, the FLSA, right?
Well, that's what the Court of Appeals said.
And I guess let me just cut to the chase. If that's the case, if you assume that the basis of my question is accurate, which I understand you may
of the
dispute,
federal law? Okay.
where did you plead that? Did you ever plead that you were asserting a common law claim for retaliatory discharge in response to violating the FLSA?
No, there was no pleading to that effect. It was in our pretrial questionnaire, but the and in our
But-
summary judgment brief.
Am I correct that in the pretrial questionnaire, it was again asserted as a violation of state law, correct?
Correct. But again, the defendant was aware of the claim because in their summary judgment, they said they're bringing a common law tort action. My response, I said that is what the claim is. The district court, in its opinion, looked at it and conceived of it as a common law tort claim. Now, all of those said that the public policy, and that was my argument below and here, the public policy is embedded in the Kansas law. It's also embedded in the federal law. It's the same policy. And relying upon this court's earlier decision in the Heisen case, you emphasize that whether the policy is under federal law or under state law, the policy is the same, and it's the underlying policy that's important.
And if I could follow up to that statement, you mentioned Heiston, and in Heiston, this court said that the policy that was underlying the federal statute was, quoting from it, identical to the public policy underlying the Kansas law.
Correct.
Is it really identical in this case? And make your best argument for why it's identical, because there are differences between the FLSA and the Kansas minimum wage maximum hour law.
Well, the essential sameness is the anti-retaliation, that you cannot retaliate against an employee for exercising their rights under the statute, their statutory rights, which is saying, I'm not getting paid overtime.
But the statutory rights are different under those two statutory schemes, aren't they?
Not I don't believe the retaliation claim is.
Understand, but the underlying rights.
The underlying rights that are granted would be, but the rights I'm focusing on and the public policy I'm saying is embedded in those rights is the right to be free of retaliation. The anti-retaliation provision, I think, is virtually identical between the two statutes. And I'm running out of my time. I just want to address on the tort claim that I do want to make clear that it is. I'm arguing that it is a public policy that is embedded in both the state act and the federal act. So I'm out of my time. Thank you.
Do we have
I have
any more
I have some
questions of council?
So,
Yes, thank you.
I wasn't clear in going through the briefs. The summary judgment motion itself, was that at the close of discovery and after the pretrial conference? I know there was a case management order, and I kind of tracked it from there, but I wasn't sure where the motion fell into the proceedings.
Well, the procedure in Shawnee County is that discovery is done. If there are dispositive motions, they are taken up first before the pretrial. In fact, we had the arguments on summary judgment at the same time that we had the pretrial. We presented the pretrial questionnaires. The judge said, I'll take the summary judgment under advisement, but there was no formal pretrial order. And that's the reason for its procedural.
Any more questions of council? Thank you, council.
Thank you.
If it please the court, again, David Cooper on behalf of the state of Kansas, the KBI, and former Director Blecka in the Court of Appeals and also before the district court. My clients included Special Agent in Charge Ralston and Senior Special Agent Hawkins. They are not the subject of the petition for review, and the judgment in their favor has been affirmed. It's no longer before the court. Keith Lumring was found by then KBI Director Blecka to have intentionally falsified his timesheet. And then when given the opportunity to meet physically and personally with Director Blecka to refute that finding, Mr. Lumring chose not to speak at all, and instead allowed his representative to make a hot stove argument about the delay between the time of the conduct of the falsified timesheets to the proposed termination. The timesheets were in February of 2008. The termination occurred in June 2008. And it's for that action, that termination, for that reason against which this retaliation claim is to be judged. Now, this comment that the court has heard about and has been discussed by Mr. Lumring to Senior Agent Hawkins occurred in October 2007 when the Southwest Kansas Drug Task Force was being formed. The conversation was, we're going to be working hard, we're going to be doing lots of drug busts and what have you. For purposes of people not necessarily in the room, because this is being streamed and recorded, the KBI and all of the defendants had adamantly, from the beginning, denied the fact that Mr. Lumry was working uncompensated overtime. In fact, he wasn't working the hours that he claimed. So I don't want it taken as a given that the KBI had a policy of not paying their agents for time they worked. But we're here on summary judgment. And on summary judgment, we assume what the plaintiff says to be true. So we accept that as the complaint, and we judge it against the framework of the well-established retaliation cause of action. What is the prima facie case?
Counsel, could I just interrupt you? I don't mean to
No, that's
interrupt you
fine.
in the flow there, but I just want to ask a big picture question with respect to Director Blecka. If this court rules against your client and you go to trial and a jury returns a verdict against Director Blecka, what happens at that point? Who pays, I guess, is my basic question. Who's on the hook here?
Who's on the hook? The state of Kansas is under the Tort Claims Act, because this is an act alleged to have been taken by Director Blecka in the course and scope of his employment.
Well, but he's being sued in his individual capacity.
It's
correct?
still for wrongful act or omission in the course and scope of his employment. And the Tort Claims Act would require that the state of Kansas defend him, which they're doing through me, and then indemnify him for any damage.
So he is indemnified.
Correct.
And there's no dispute about that from the state.
I'm not here under any sort of quasi-reservation of rights sort of thing, if that's your question.
It is. I had another question about the discovery, and I accept what you're saying about the alternate universe of summary judgment. So we have to operate as if the KBI did have a culture, if not an indirect policy of making sure, of having people work when and not claim hours. So I appreciate that. Was there any evidence that any other KBI agents worked that policy? In other words, that they weren't turning in time, that they had put in on their timesheet?
The evidence of record is that when Mr. Lumry submitted his claim to the Department of Labor, and the Department of Labor did its investigation, they found that 10 agents were cut a check for uncompensated overtime.
Excuse me, when did that happen?
After he submitted a written complaint to the Department of Labor after his termination, the Department of Labor did an investigation. Mr. Lumry received a check in excess of $40,000 based upon his claim of working 20 hours per pay period of uncompensated overtime.
And were those KBI agents terminated for making false timesheets, for underbilling the KBI? Because those would be false statements.
They were not. And I don't know the storyline. Getting back into the flow, though, before we get to the prima facie case, there's the threshold issue, which is on the state's petition for review. Is Director Blecka an employer under the FLSA? The Court of Appeals said yes. All three judges did as well. There's no 10th Circuit decision. The 9th and 11th Circuits say the economic realities of state employment is that the legislature is the employer. All of the managers and supervisors are not the economic reality employer because, quite simply, they don't make the budget, they don't raise the funds, they don't cut the checks. The managers don't. The legislature is responsible for that. And I know that this body is well aware of where funding comes from. The Court of Appeals chose to follow the 6th, 7th, and 8th Circuits and go the other way, and I'm not going to waste a whole lot of time discussing that.
But let's talk about that a second.
Okay.
If we adopted that position, it would eviscerate the law, would it not? Because plaintiff wouldn't have any ability to sue a branch of government as an employer.
As he would not be able to sue the state of Kansas. That's correct. And that We do have cases in Kansas where you're not covered by the minimum wage, maximum hour law because you're covered by the FLSA, but the FLSA doesn't give you a remedy. That's the motor carriers exception cases. With respect to the prima facie case, and here's where the case has gone off the rails and brings us here today. The prima facie case requires that Mr. Lumry prove he engaged, or at least present evidence that he engaged in activity protected by the FLSA, and that he suffered adverse action subsequent to that because of that. That's the third element, causation element. Remember, the statement was in October 2007. The termination was in June 2008. Everybody is focusing on this statement by Mr. Lumry to Hawkins. There is no evidence, and in fact, the evidence is to the contrary, that Director Blecka knew that Mr. Lumry had ever made that statement. The only information available to Director Blecka was in Special Agent in Charge's and Randy Avey's May 1 preliminary report and May 30 final report. There's no mention of overtime or uncompensated overtime in those reports. You cannot impute the conversation between Hawkins and Lumry to Blecka, or that Blecka's decision was because of that conversation. And so when the briefs say, the state says, the Court of Appeals is right that there's no prima facie case, it's because there's no causation between that comment and the action. Secondarily, when we talk about the Caston case, I'm trying to call it Castor, the Caston case, that conversation and that comment is not a statement availing Mr. Lumry of his rights under the FLSA. He's not saying, pay me for the time I'm working. That is availing oneself of one's rights under the FLSA. And it's certainly not a conversation that put Mr. Blecka, then Director Blecka, on notice that such a claim was being made. That is where, as I said, that's where we go off the rails. We don't make a prima facie case because, one, the protected conduct doesn't meet the Caston threshold, and two, there's no causation between the two. Then, for reasons that were briefed both to the district court, to the Court of Appeals, and are in the briefs on the petition for review, there are other reasons to affirm the dismissal. When you finish the analysis on the retaliation claim, you go past the prima facie case. You then, burden then shifts to the defendant to proffer a legitimate, non-discriminatory reason for the adverse action. If the defendant has done so, and that's where I started, he was fired for filing false timesheets. And when given the opportunity to refute the fact that he had falsified his timesheets, he stood mute. So the burden then shifts back to the plaintiff to present evidence of pretext. There is none. That is an alternate basis for affirming the dismissal and the summary judgment. Moving on then to the public policy, should there be a common law retaliatory discharge claim based upon the policy embedded in the minimum or the minimum wage, maximum hour law. And again, we contend there should not be for a variety of reasons. One, what is the public policy being expressed? Again, the pleadings, which were not superseded by a pretrial order, and I know Justice Biles that at some point in time, doing summary judgment practice before you have a pretrial order sometimes means a summary judgment briefing is a shot in the dark because you don't have a fixed target to hone in on.
I really was asking because I wanted to make sure that plaintiff had all the opportunity to do the discovery that was set out by the district court before you dropped in your motion.
discovery was complete. And all that was ever pled in the petition, the amended petition, and even the pretrial questionnaires was a state law statutory retaliation claim under the minimum wage, maximum hour law.
Well, counsel, I'm going to clarify that. You just said what was being pled was a statutory retaliatory discharge claim.
Yes.
Is there a statutory right for a private cause of action, a statutory right for a private cause of action for retaliatory discharge in state law, in the Kansas minimum wage maximum hour?
You mean for employees not otherwise covered by?
Yeah, just let's assume we have an ex-employee who is covered by the state law. Is there a private statutory right? to bring
That action
cause of
goes through the Department of Labor.
Okay. And so, as I read the pleadings, I agree, it's hard to figure out, but if we give a construction most favorably to Mr. Lumry, it appears he was making a common law claim, not a statutory claim.
Which leads to the rest of my argument, because for summary judgment briefing, I assumed we're going to deal with that cause of action.
By that cause of action, you mean a common law?
A common law cause of action. But it should not be recognized, and why not? Because his cause of action is a federal FLSA statutory retaliation claim, which provides him full remedies.
Can I ask the same question I asked the opposing counsel? Do you agree that the underlying public policy that underlies the FLSA is identical to the public policy that underlies the state law? And if not, why not?
No, because the state law is different. We would be arguing about the difference between 40 hours and 46 hours. Because the maximum hours under Kansas law is 46, not 40. And then the FLSA has a variety of exceptions that you have to wade through the weeds to decide, do we have a motor carrier exception? Do we have a portal exception that we're applying? And the compensability of your wage and hour claim.
Counselor,
differs.
excuse me, why does it make any difference on the public policy if you make someone work uncompensated overtime, whether the statute says 40 hours or 46? I mean, it's still the same wrongful conduct. The number of hours seems to me to be a distinction without a difference on public policy.
Except that the Fair Labor Standards Act provides a remedy. And
That's a different question.
I figured you might.
Yeah, I think that just to be a little orderly in our discussion here, we have at least a couple questions out there for you. And the first is whether the public policy, as opposed to the specific provisions underlying both the federal and state act, is identical or not. And your response, as I understood it, was to tell us a bunch of specific provisions that are different. We want to talk about the public policy.
And I think it was as Justice Johnson refined it. If the policy is to oppose working uncompensated overtime for retaliatory provisions, it is the same policy. The question then becomes whether there's an adequate and alternate remedies,
That's the
which
second
is
question.
not an affirmative defense. Because the cause of action doesn't exist, this court hasn't said it exists. It would be the same as saying, I need to plead the defense of liberty gibbet because somebody's come up with a new cause of actions nobody's ever heard of. It's not an affirmative action. The question is, does the cause exist, and does this plaintiff possess that cause of action? Why? They have an adequate alternative remedy. It's the same sort of thing. The state of Kansas has a firm public policy against discrimination on the basis of age, race, etc.
Counsel,
But the remedies are through the KHRC proceeding.
The Court of Appeals, as I read the ruling, held that Mr. Lumry did have an adequate alternative remedy because his claim against Mr. Blecka was being allowed to proceed. Now, if we rule in your favor, you're asking this court to find that Blecka is not subject to suit because he's not an employer. Does that sort of vitiate your argument then on adequate alternative remedy?
It depends on if you're looking at it in the micro in this specific instance, or if you're looking at it in the macro. And again, we go to the motor
Well,
carriers
I would just
cases
put
where
it bluntly, if Blecka can't be sued,
Mr.
if
Lumley
you
doesn't
win
have a
that
remedy.
claim, why does Mr. Lumley have an adequate alternative remedy under the FLSA?
Frankly, because he's already gotten his check.
So you would say that the administrative procedure that he went through gave him that adequate?
Yes. And again, on the macro and under the motor carrier.
That wasn't a remedy for his discharge, though, was it?
Not for discharge, no. I'm long out of time. Are there other questions before I see BCD?
Any more questions? Thank you, counsel.
Let me address the adequate alternative remedies doctrine and first talk about whose burden it is to raise. It's my contention that the adequate alternatives doctrine is an affirmative defense that the defendant has to raise, or the court on its own motion can raise, and once it's raised, it needs to be addressed. But in this case, in my position, it's not part of the plaintiff's prima facie case to show that. Just like in an ordinary case, the plaintiff doesn't have to show that the statute of limitations has not passed. It's the burden of the defendant or the court to raise that issue. And in this case, the adequate alternative remedies doctrine was not raised to the district court. It was not raised by the defendant. It was not raised in the briefs to the Court of Appeals. The first time it came up was in the Court of Appeals decision sua sponte, so that I never had the opportunity to address why the FLSA was not an adequate alternative remedy. And that was the reason for the petition for review, was to explain why the FLSA is not an adequate alternative remedy. I concede that a court can, and this court has, raised it sua sponte on its own, but the plaintiff should at least be given the opportunity to explain why he or she doesn't believe that it's an adequate alternative remedy. And the reason in this case is because the FLSA can only be asserted against Mr. Blecka in his individual capacity because the doctrine of sovereign immunity. That means that Mr. Blecka, that there is no vicarious liability. Mr. Blecka is only liable for his own wrongful actions. Therefore, if the jury believes, as he testified, I did not know that Mr. Lumry had made a complaint of unpaid compensation, then there is no liability. In contrast, the common law tort claim is against the KBI as an agency, and the Tort Claims Act recognizes vicarious liability, so that the agency, the KBI, can be liable for the wrongful acts of Mr. Hawkins. And it's Mr. Lumry's theory that he complained to Mr. Hawkins, that then Mr. Hawkins, when he was motivated by a retaliatory animus to then make a false report up the chain of command, up to Mr. Blecka, that Mr. Lumry had falsified his timesheets. Mr. Lumry denied that, offered to take a lie detector test. That eventually led to his termination, and under a vicarious liability theory, or what the courts have called a subordinate bias theory, the entity, the KBI, can be liable for what Mr. Hawkins did, as well as what Mr. Blecka did. And that's the inadequacy here, is that because of the doctrine of sovereign immunity, only Mr. Blecka can be sued, and there is no vicarious liability.
What about the point that you can't connect the dots between the statement made by the plaintiff and Director Blecka?
And that goes again to whether or not Mr. Hawkins is a biased subordinate, because Mr. Blecka testified that he relied upon the report by Mr. Hawkins, that Mr. Hawkins believed this was an integrity issue. It was not just that his timesheets were not just a mistake, but that it was intentional lying. And Mr. Lumry's contention is that that's a false report, and that the reason why Mr. Hawkins lied to Mr. Blecka to get Mr. Lumry fired was because of retaliatory animus.
And remind me, there was an investigation by another special agent.
Correct.
And my memory is that special agent's conclusion was not definitive. But that investigation and report got to Director Blecka before the termination, is that correct?
That's correct. That other investigator was, it's spelled E-W-Y, but it's pronounced A-E. And his position was, I've looked at this, I've talked to Mr. Lemmer, and frankly, I don't know whether it's a mistake or intentional falsification. Any other questions?
Yes.
I'm sorry, Chief.
You go ahead.
Just a house cleaning matter. The remedy here, you're not asking for Mr. Lumry to be reinstated, is that correct?
That is part of the claim, yes.
It is part of the claim.
Yes, part of his remedy. The back pay, front pay, and then he's seeking to be reinstated.
Okay, thank you.
Well, let me rephrase that. That was the case in the pleadings. At the current time, since he got terminated, Mr. Lumry has had cancer, and although he's recovered from that, he's not able to be an agent. So technically, I was asking for reinstatement, but now he is not physically able to be reinstated.
Thank you.
That was my question. What are you asking us to do in terms of a remedy? I think you've answered it.
Right.
Thank you.
Thank
Any further questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.